Copyright in these lectures is either owned by the ANU or a third party who has licensed the ANU to use it. Students may use the recording for personal study only. No lecture may be communicated online, copied or shared without the prior permission of the ANU.
At another time. It's a fascinating question. Good afternoon, everyone. It's week 12. It's property. I think it's my favourite lecture of all this semester. But everyone has their favourites. It may not be yours, but hopefully you will still find it interesting. So this week's is property, week 10, which is from chapter 20 of the textbook, or draws upon chapter 20. Some of the cases discussed aren't in the textbook. And then next week we'll do intellectual property, and then a little bit of the intellectual property content will be discussed in the week 12 lecture as well, and the week 12 lecture will be revision. So we'll go through some of the answers in the 2018 exam paper and 2017 as well, noting that you've already done a number of those questions already in your tutorials. So there's some questions there for you that you will be able to answer by the end of the lecture, hopefully. What is real property? If I buy a house, do I own the air above it and the minerals below it? And what does ownership mean in that context? If I agree to rent a house or buy a house, will I get the dishwasher, microwave and bird bath? Can I gift part of a joint tenant or my joint tenancy to children in my will? And finally, perhaps the most fun part of the entire lecture is the question, are finders keepers? So let's start off with the question of what is property. So property refers to objects of ownership, real and personal property, and rights of ownership. The major classifications in property law are real property, and if you're trying to remember how to remember what real property is, just remember that you buy real property from a real estate agent. So real property is land, and then personal property can be divided into tangible, something you can touch or hold in your hands, such as goods, which you did consider in the context of the Sale of Goods Act. And then intangibles, such as trademarks. So intangibles we'll talk about next week. This week we'll look at personal property that's tangible, and then real property as well. So let's get into looking at real property. So if you're purchasing land, or if you own some land, you own the dirt, the trees, but also anything that is attached to the land. For example, a house. And then anything that is attached to the house, that is a fixture, is also part of the package of ownership, part of owning the land. So in order to determine, most of the cases have arisen because there's been a sale of land. People have purchased some land, and then the things they thought they were getting with that purchase weren't included. And so they've gone to court. So if an item can be determined to be a fixture, then it's counted as being part of the land. If it is a fitting, it's not part of the land, and it can be taken at the sale. So if you're trying to determine whether something is a fixture or a fitting in an exam question, you will always need to apply the test in APA and Coronio. In this case, so the test is there for you, the degree of annexation and the purpose of annexation. I'll just give you the facts quickly, but they may not necessarily be that important. The most important thing is the rule. So in that case, the New South Wales Supreme Court had to decide whether or not seats that were bolted to the floor and attached to one another in a theatre were fixtures, that is part of the land, or chattels, that is a fitting. The court decided on two tests that are outlined on the slide there. The assumption generally was that if something is resting on the land by anything but its own weight, then it is a fixture. But if it is only resting by its own weight, then it is a fitting. And part of what the court had to consider was the degree of annexation, so how much or how is something being attached to the land? So is it concreted in, is it bolted in, and how easily could it be removed? And then also you always need to consider what was the purpose of annexation. So what was the purpose of attaching it to the land? And the purpose element actually has a higher weight when you are applying this test than the degree of annexation. Okay, so any fixture and fitting case, you would start off with the test in APA and Coronio, and then you would then consider if any of the following cases assisted you in answering the question. You wouldn't talk about all of the following cases. So the Diencourt and Gregory case is in the textbook. In that case, the court had to consider whether some tapestries, some ornamental statues of lions in the hall, it was a very grand English home, the staircase and gardens, and some vases resting in niches in the stone garden seats were fixtures or chattels. So what had happened is the buyer had purchased the property thinking all these things were coming with the property. And then when they went to move into the house, they realised that the tapestries had been taken down, the garden furniture had been taken away, the wall hangings, the vases, everything. The house had been stripped of all those items. And the vendor's argument was, well, these things weren't bolted down, they were resting by their own weight, they were quite easily removed, they are fittings, they are not part of the home. The court disagreed with the vendor and supported the buyer's argument. The court held that the tapestries were fixtures because they were integral to the decoration of the room, and the statues of the lions, the garden seats and the vases were fixtures because, and this is the important test that you can apply to other cases, is because they formed part of the overall architectural design of the home. They enhance the enjoyment and utility of the land. okay, even though they could be easily removed. So another case where it's sort of counterintuitive, something that was very strongly attached to a building was found to be a fitting because of the intention behind it. And part of what you need to think about is the item being attached to the land or the home to enhance the enjoyment of the home, or to enjoyment or utility, or to enhance the enjoyment and utility of the item, of the good as a chattel. So in this Canadian case, which has been affirmed by Australian decisions, knowing of course that Canadian decisions don't have precedent value as such in Australia, the court said that, so the question the court had to consider was whether ATMs which had been attached to the building were fittings or fixtures. The ATMs were connected, had electrical cords, telephone cords and alarm cords, and they were also fairly reasonably securely attached to the building for obvious reasons because they contained cash. But the court said these cords could be very easily disconnected, and they could be disconnected without causing any damage to the premises. And the purpose or the object of annexation, the purpose of attaching the machines to the building, was not to make the building more useful, but to make sure that you could actually use the ATM, was to enable the enjoyment of the ATM as a chattel or a good. Okay. So therefore the court concluded at paragraph 46, it is my view that the machines are not installed for the enhancement of the land, even though the banks benefit of having them installed. They actually have been installed, in conclusion, to enhance their use as chattels. Okay, now there's a whole lot more examples of the court's application of this law in the textbook. In an exam situation, you certainly would not be mentioning every one of these cases. You would be definitely mentioning the test in APA and Coronio, noting the further detail provided in those two cases if necessary. And then you would only mention any of these cases if they were directly relevant to the facts of the particular question. Okay, I'm just going to give you 3 or 4 minutes just to talk to the person next to you. And if you're on your own, if you don't want to make any friends and you want to do it on your own, that's fine, or you can find a team to sit with. Just to have a really quick chat to work out whether you've got a 50-50 chance of getting it right. And the answer is given to you because I've told you where it is in the textbook. But if you just take 2 or 3 minutes to work out whether you think a dishwasher connected by easily removable plumbing is a fixture or fitting, an electric stove, bowling lanes, air conditioners, clothes dryers and printing presses. Keeping in mind the test in APA and Coronio, 2 slides earlier, and also thinking about with each of these items, are they being attached to the land to enhance the enjoyment of the land or the home, or are they being attached simply because that's what you need to do in order to use the good? Okay, and attachment doesn't just mean that something's been bolted in, it could also mean simply a plumbing cord for water or electricity. Okay, I'll just give you 2 minutes. You won't need to report back one by one. I'll just ask the group as a whole. Okay, let's find out what you think. What do you think about a dishwasher that can be easily removed? You think it's a fixture? Yep. No, a fitting. A fitting, yeah. Dishwashers are kind of tricky because the court's changed its mind. The court hasn't changed its mind, but in different sets of circumstances, the court has reached a different view on dishwashers. So, can you use a dishwasher without attaching it to plumbing or electricity? No. Okay, so that's the strongest argument, and that's the argument the court took in the Siegel and Osborne case. You can't use a dishwasher without attaching it. Okay, so the attachment is to better use the good. Okay, but if you had a dishwasher or an electric stove that has been not just attached to electricity, but has been put in a specially designed kitchen cupboard or recess that's been bolted in or something like that, then it's more likely to be a fixture because it's been attached to permanently enhance the kitchen or the land. Okay, so that's good. Bowling lanes, fixture. Yep, the court found in that case that the purpose of attaching them to the bowling alley was to better use the building. What about air conditioners? Fixture? It depends how much you know about air conditioners. Apparently for air conditioners to work and so they don't make a lot of noise in your house, you have them outside on a little sort of tray. You don't permanently bolt the air conditioner itself to the home. You have it sitting on top of a shelf as such. So because of that, air conditioners, even if they're not attached to the building, could still be a fixture because they were placed on pads to minimise the noise and vibration in the home or in the building, and they were intended to permanently be part of that property. Okay. What about a clothes dryer attached to a laundry wall? Fixture? Fitting? It's hard, isn't it? And both the words start with F, which I think makes it difficult. Why might it be a fitting? If it was just attached to the laundry wall so as to better use the dryer, because there wasn't enough room in the laundry to have it on the floor, for example, or you didn't want it bouncing across the floor, that would make it a fitting, okay? But in that same case, the electric dishwasher, because it was permanently attached to household plumbing, it was a fixture, okay? So you really, what you really need to be thinking about, which you'll get from the facts in the exam question, is some information about whether it's attached. What was the intention? Is it to use the good, because you can't use the good unless it's somehow attached to the home, or if it's intended to be a permanent feature of the home, so you've made a special shelf for it and it's enclosed and so on, then that's more likely to be a fixture in that context. What about a microwave that's just sitting on the bench that's plugged in? Fitting, excellent. We haven't got a case on that yet, but that's a good example, I think, for you. Okay, and the printing press? Again, this requires a bit of an understanding about how printing presses work, which I have to admit I didn't have till I read this case. Apparently a printing press, you need to bolt it down so it doesn't sort of jump across the floor. Okay, so that was a fitting, because the reason it was bolted down was to better use it as a printing press, not for any other reason, not because they intended it to be there permanently. And we'll try to give you enough information in the exam question about what the intention was. So what about a house on land? So your starting point with a home, your presumption can be, or you could start off when you're writing your rule, you could say, generally, structures on land are fixtures, okay? And your authority for that principle is Reed and Smith. Okay, so that is the beginning of your answer if you're looking at a structure or a building on land. Of course, though, there are always exceptions to the general rule. Okay. In Hawkins and Farley, the court found that the shed was a fixture because it was bolted onto concrete blocks and the concrete blocks were themselves buried into the ground. Okay, and the intention was that it would be there permanently. What about a site hut for a building project? So if you're building a road and you've got a site house so the workmen and women can have their lunch, does that tend to suggest it's intended to be there permanently or temporarily? Temporarily, okay? So a site hut that's been built for a building project, the building project having an end date, even if it's dug into ground and attached to concrete and bolted in, would still be, or in this case was still found to be a fitting because the intention was temporary. Okay. The caravan park case. So some people in Australia will live in a caravan park for decades, and it's their home and it's their permanent accommodation. But because the caravan park is still because the caravan home is still a temporary home that's on wheels, there is still an intention, the court found in that context, that it could be moved one day, even if the occupier didn't intend to move. So the court found that a caravan park home could be a fitting. So of course, again, in an exam, if there's a structure on land, you wouldn't necessarily refer to all these cases. You would definitely refer to Reed and Smith and then consider whether one of the exceptions applied based on the facts. Has anyone got any questions about that? Okay. Now, there's also quite a large body of law about tenants' fixtures. So what does a tenant own if you're renting a house? So you're not the owner of the land and you're renting it off someone else. What are your rights and entitlements when it comes to putting things up or attaching them to the home, and what can you take with you when you leave? I'll give you the common law in a moment, but I think it's important to note up front that tenants' rights are governed by legislation in the ACT, and that Section 8 of the Residential Tenancies Act 1997 provides that all lease agreements, so all agreements between a tenant and a landlord, with very few exceptions, must contain the standard terms that are listed in Schedule 1. And the standard terms are there on the slide for you. So in an exam question, if you've got a tenant who's attaching things to property or wants to take things with them, start off with the residential tenancies legislation. So you can't make any alterations, add any fixtures or fittings without the written consent of the landlord or the lessor. Same thing. The landlord can't unreasonably withhold that consent. And if a tenant does get permission to, for example, put up a shelf in the lounge room or put a deck on the back of a house or something like that, a fixture, when they leave they have to take that fixture down. The phrase is make good, so that you need to take the shelf out and then also put, paint and plaster so it looks like it was never there. And if a tenant forgets to do that, so they forget to or chooses not to take the shelf down or whatever, once they've left the property, the fixtures become the landowner's. Okay, which makes sense because the landowner owns the home and everything attached to the home. And I've got the common law background there for you, which gives you some illustration and context for where the legislation came from, but is certainly much less important than the ACT legislation. Okay, embellments, it's not going to be in the exam, is not accessible. But if you're interested in what happens if you're a farmer, if you're a tenant who's leasing land and then sowing seed and is not around during harvest time, there's provision for that there for you. Okay, so let's look at the rights to airspace. So if you own land, how far does the ownership go? So if you own the dirt or the trees or the grass on your block of land, what do you own above it and what do you own below it? And what are those rights? So the first thing I want to look at is rights to airspace. Any property law question where there's an airspace issue, you should usually always start with a reference to Bernstein and Sky Views. Noting that in an exam you don't have to write the whole case name, the short name is fine, so it'd be all right just to write Bernstein with an underline or Sky Views. And your rule would be that generally owners of land have a limited right to airspace, and that right is limited to what is necessary for the ordinary enjoyment of the land. In the Bernstein and Sky Views case, which is in your textbook, I think, 613, Mr. Bernstein was contacted by Sky Views, who offered, this is sort of in the 1970s, if it's before you had Google Earth, and Mr. Bernstein was sent some aerial photographs of his land, and he was told that, if you want to purchase these, maybe they didn't send them to him, they might have just written to him and said, we've got these photographs, and would you like to purchase them off us? Landowners sometimes do quite care about having aerial photographs of their land, and perhaps this is a way that Sky Views made money. Anyway, Mr. Bernstein was outraged that this plane had flown over his property and taken photos. So he demanded that they hand over the negatives to him or destroyed the negatives. And Sky Views refused to do this, and Mr. Bernstein took Sky Views to court alleging trespass because they entered into his airspace. So the court had to consider, was flying over Mr. Bernstein's land and taking photographs trespass? And the court said, well, Mr. Bernstein, you do have some rights as a landowner, okay, but it's restricted to what is necessary for the enjoyment of your property. And the evidence was that Mr. Bernstein's enjoyment of his property had not been interfered with by Sky Views overflying it. In fact, I don't think he even had realised they had flown over his land to take the photos because they were so high up, it didn't disturb him at all. Therefore, there was no trespass. Okay? So, that's the Bernstein case. If the plane had been flying very low and it had been scaring away his cattle or his sheep, or if he hadn't been able to enjoy sitting in his garden and having a cold drink because there'd been so much noise from the plane, perhaps then he would have been able to get damages for trespass. Now, cranes, signs, scaffolding and cladding have all been found to trespass the airspace of property owners. Now, these cases are all really about construction in a high-density city environment. Okay, so in order to build the high-rise, you might need your crane to flow over the neighbouring car park. Okay, and I guess the general rule there is that a licence fee can be imposed by the landowner. So even if it's not affecting their enjoyment as such that the crane is coming over their land, if it's a context where they could potentially charge a licence fee, which is really charging the other party for permission to go over their land, then the other party should negotiate with them to reach an agreement. So let's have a look at the Bendel case. So the Bendel case involved the construction of a multi-storey building using screens to protect the work and prevent building material falling from the building. There are lots of examples of this type of construction around Canberra at the moment, and I'm sure anyone who's been to Sydney or Melbourne or any large city that's under a lot of development would be familiar with the sight of the scaffolding coming out from buildings. So the screens moved upward as the building was constructed, but they encroached on the airspace of the plaintiff's building. And there was also a crane that was coming across and encroaching upon the space. And the court concluded that an injunction was warranted. Do you remember what an injunction is if the court orders an injunction? Court's ordering that somebody has to stop doing something, okay, so ordered them to stop using the crane and having the scaffolding encroach on the airspace. So the court said that an injunction was warranted, notwithstanding that the building work was going to be completed in only 5 weeks' time. So the defendants, the construction company, argued that it would be an undue hardship to have to stop work while they worked out a new method of construction. But the court was not persuaded by this argument, and the court concluded that I do not see it as a hardship at all. It is all the defendant's own doing. So he's saying it's the construction company's fault. It's the result of them using a construction method which would cause encroachment and obviously involve the need for them to get permission, yet they did not obtain the permission. Their own evidence shows that by adopting the construction method which they have used, they have made a saving now quantified at $239,000, which back in 1991 was an even bigger sum of money than it looks like it does to us today. So the Bendel case is really a reminder that if you're encroaching on someone else's airspace, even if it's just a little bit, even if they're not even using the space, you should negotiate with the other party for permission. And that negotiation will usually result in you having to pay a fee for a licence. We haven't talked about licences in much detail at all, I don't think, in this course. A licence is not a lease or renting, it's basically permission to do a certain thing with someone else's land. But it's not doesn't give you anywhere near as many property rights as actually leasing the land, so it's a lot cheaper. Now, Lang Parade and Paluzzo is another case about encroaching into airspace, and in that case, I can put the details online, but the main thing to remember or to take from the Lang Parade case is that the licence, even though you should get a licence as evidenced by Bendel, if you are the landholder, you shouldn't unreasonably refuse to grant a licence, or you shouldn't charge too much for the licence. You should charge a reasonable fee. They were trying to get $1 million, I think, in that case, which the court said. So the respondent offered $5,000 and the applicant wanted $90,000, and the losses would be more than $1 million to the construction company. And the court found that really they should have agreed for the much more reasonable rate for the licence fee. Okay, so that's air. What about your rights to below the ground? Rights to the underground, which makes it sound like rights to the underground rail, but no, just what happens underneath your house. What are your rights to what's under your house? So generally this extends to the use and enjoyment of the land and the properties on it, or directly under it, but not to areas the landowner cannot access or utilise. And this right is curtailed because of so many land and planning regulations. So the government will reserve rights to access the land below your home for sewerage purposes, plumbing purposes, electricity, NBN, and so on. So it's quite a restricted right. But let's start by looking at Grigsby and Melville, which I think is quite a fun case. Ooh, it's an English case, and it is also in the textbook on page 615. So in this case, a butcher owned owned a duplex, essentially, so two homes that were next door to each other. He lived in one property and he used the property next door, which was partly residential, for his business. The properties had separate entrances, but they were connected by doors on the ground floor and the upper floor. There was a cellar underneath the sitting room of one of the properties. So it's going to be difficult for the people listening, but for those who are watching, we have two homes next door to each other sharing a wall. This was all fine until the butcher sold the home to two different people. So the butcher lived in one and the other side was his shop. The problem was the shop entrance inside the shop had stairs down to the basement, which is where the meat was kept traditionally. It was built many years ago, years before it came to the court. So the butcher would walk from the stairs, from his shop, down stairs to get the cold meat and then go back up. That was fine. And then the properties got sold, and suddenly the person who purchased this property didn't like his neighbour accessing the cellar, even though he couldn't get down to the cellar. So he brought an action to argue that the land directly below his house was his. So the person who won was the person who lived above the cellar. Okay, and then he must have had to put stairs in or something. Okay, and that's really just the idea that if you own the land, you own the buildings below it. Okay, even if you can't access them directly. Has anyone got any questions about that case? Okay. I've just got a slide there for you, just providing a bit more detail for you about just in reality how restricted the right is, or how limited your right is to the land below. The Crown or the state, when they grant land ownership to people, will reserve rights in relation to all sorts of things, particularly minerals, which is where a lot of the money is. Did I put it up there? There's a few other cases in the textbook, the Edward and Sims case and the Boccardo case, where there were people trying to, the plaintiff was concerned that there was beautiful caves under his home, and the neighbouring property had the entrance to the caves, to the tunnels, and he wanted money off the neighbour or wanted a trespass injunction from the neighbour for coming under the caves. And the court didn't uphold that because he didn't have access to it. That was an American decision, Edwards and Sims. And there's another case, Boccardo, which is on the screens there, where the court acknowledged there had been some trespass, but the damages were so small because it hadn't interfered with enjoyment of the land. You can have a look at those in your own time. They're of less precedent value to us because they're in other jurisdictions. Okay, so let's look at types of tenure. So property lawyers in England in like the 1500s used to be the superstar lawyers, because all the wealth was tied up in what land you had and what rights and interests you had in land. And so I could definitely teach for a whole semester, possibly a year, on types of tenure in property, which I'm not going to. You're just going to get a couple of slides. So tenure is the conditions under which land or buildings are held or occupied. All ownership of land is granted by the Crown. The Crown reserves its rights. The most, the best type of land interest is freehold. You own the land directly from the Crown or the state, not through another person. You could have an estate in fee simple, which is of unlimited duration. You can sell the land, you can sell it to other people, you can deal with it as you please. Some people might have a life estate, which means you only own the property for someone's life. It's tied to how long an individual lives for. These used to be quite popular amongst men leaving property to their wives. They might say, back when women didn't have many assets, they might give it to their wife till she died, and then the asset would be divided equally amongst the children, for example. It's not the best type of interest. There's a lot of obligations. If you have a life estate, you have to maintain the property and look after it. You might be able to rent it out in your life, but you certainly can't sell it. I'd much prefer to receive an estate in fee simple than a life estate. So another type of interest in land is a leasehold. And those of you who are renting in Canberra may be familiar with this. So it grants another person the rights of possession of land for a definite period. When the lease ends, the landlord regains both possession and the rights of use. All land in the ACT is held on a Crown lease. None of those Crown leases have run out yet, so we don't know exactly what will happen. Hopefully we'll just pay a small administrative fee. But when you're leasing property, you have the rights of possession, and the landlord gives up some of his or her rights. So the landlord sells the right of possession to someone else for a specified period of time. Okay, so if you're a tenant in a property, you can enter and leave the property as you please. Your landlord needs to give you notice before they enter the property, for example. The TORM system applies throughout Australia. This is ownership in land is registered in a document, the Land Titles Office. Legal interests are acquired only through registration. There might be some remedies in equity. When you do 7057, Kurt Stevens will teach you a bit more about the priority of different interests. I'm not going to go into any more detail with you about that today. Okay, and then finally, I just wanted to look at ways of co-owning real property. So how can groups of people own land? And the two divisions here are joint tenancy or tenancy in common. So if you have a joint tenancy, each joint tenant has an equal and undivided interest in the property, and there's a right of survivorship. So if you have two joint tenants, you would both have the same amount of interest in the property and it can't be divided. And if one of you dies, the other person takes on the full interest. Okay, if three of you had an interest in the property and one of you dies, then the remaining two people have the interest. Okay, so it accrues to the other joint tenants. You do not need a will to distribute that interest. And you cannot pass your interest in a joint tenancy to someone else through a will. A tenancy in common is different. Each tenant in common owns a distinct share of the property, and that share does not need to be equal, and there is no right of survivorship. So just keep it simple, you had two joint tenants, you each had 50% each. If one of the joint tenants dies, there's no accrual to the other joint tenant. Instead, that share is distributed by will or intestacy to that person's heirs. If nothing is specified, then the presumption in the ACT is that there is a joint tenancy, which is the first scenario there. Okay, that's intermission. Let's take a 10-minute break. 10 minutes by whatever your watch is, or just come back at 5 o'clock. Hello, do you want to have a seat? Or you... Okay. Yeah, so it might just be, it's whoever's named in the will. So the wife might have a life estate until she dies, or it might be until someone else dies, but the person will be named in the will. So that basically your interest in that property is limited by the life term of the other individual or someone else.
So can give me some specific example of
Yeah, so the husband might say, I leave my house, the family home, to my wife as a life estate. And when she dies, I would like it distributed amongst my children. Or you might say, I leave the interest in the home to my cousin until my wife dies. Or until someone else dies. Yeah, it's a way of giving someone property, but it's quite a limited way of giving them property because they lose it once they die or another named person dies.
Just some limited time. situation, we can call it tenancy in common.
Yeah, so that means you've got your own distinct share. So it could be a percentage. You might have 15% each, or I got a board.
So if it,
I'm trying to find a whiteboard mark.
so if the question didn't say anything, so we just assume it's a joint tenancy. So how it explain when it is a tenancy in common?
How is it explained? We would tell you in the question.
It will directly tell me this is a tenancy in common.
Yeah.
All right, thanks.
That's okay. It's a bit confusing. All right, we might start 1 minute early because I think everyone's back in the room. So we're going to start looking at finders keepers, and then we'll also look a little bit at some equity and mortgages cases, and then finally hopefully there'll be time to do a couple of practice questions at the end. So what is possession? Person who has possession of an item has it in their care and control. You can have possession of something that, you can lawfully have possession of something that you are not the owner of. So possession means physical control and the intention to exercise control. So there's usually, I haven't written the exam yet, but there's usually one finders keepers question each exam. There's certainly a finders keepers question in your tutorial for next week. The general rule is that the finder has a better right than the finder of an object has a better right to keep that object than anyone else in the world except for the true owner. Okay, so the cases that we'll talk about in this section is when different parties are contesting who has the best claim to that object and the true owner is not around. Okay, the true owner can't be found, or perhaps the true owner died hundreds of years ago and their treasure has been found by someone else. Okay, so it's really often about working out the priority, so who has the better claim. But please always remember that the person who has the best claim is the true owner, but usually they won't be around. Any finders keepers question should really start with the considerations set out in the Waverley Borough Council case. This case is actually mentioned at the very end of chapter 20, but I'm mentioning it here at the beginning because it sets out the rights and obligations of finders and occupiers. And even if you have the better claim to the object that you found, you still have some obligations as well. For example, to make an effort to find the true owner and to look after the property that you have, and also to hand it over to your employer. So the general rule for finders is that the finder has a better right aside from anyone except from the true owner unless the item is found in or attached to someone else's property, or if you find the object during the course of your employment. Okay, so Amory and Delamere is the case for possession. Well, really stands for the principle that the finder has better properties than anyone else except the true owner, although there are some caveats to that rule. So in this case, a chimney sweep found a piece of jewellery and he took it to the jeweller to get it valued, and the jeweller's apprentice took the precious stone out of the jewellery and gave it back to the chimney sweep. And the chimney sweep asked for it back and the jeweller said, "It's not yours." Probably also thought you're a poor... Do people know what a chimney sweep is? No? A lot of these old English cases have sort of occupations that haven't been around for a while, although I believe chimney sweeps still exist. So if you have a chimney, so you have a fire to keep the house warm and the smoke goes up the chimney, and after a while they can get too full with ash. So either they're not ventilated properly or they could be bringing soot down every time a bird gets in the chimney. There's also a lot of the old homes in England have fairly complicated chimney systems that need to be cleaned out. So a chimney sweep was someone who would climb up the chimney and clean it out with a brush, and they'd be very black and often quite small in size. That's just context for you, not that important really. But yes, so the chimney sweep sued. I think bringing an action in court must have been a little bit cheaper in the 1700s than it is today. And the chimney sweep won because the true owner couldn't be found, and the chimney sweep had it in his possession. He found it. He had a better claim than anyone else. But let's look at some exceptions to that general rule. So finders keepers, you should start with Amory and Delamere and then consider whether any exceptions apply. And usually one will, but you need to work out which one. So firstly, articles found in another person's property will belong to the owner of the land. Okay, and we've just talked about fixtures, so this hopefully makes sense to you, right? So something dug in under someone's land belongs to the owner of the land. Okay, even if the finder lawfully found it and was lawfully on the land and put their own energy and effort into finding it, the land owner will still own it, because the owner owns the land and they own anything attached to the land. So in this case, Mr. E leased land to the gas company, and while the gas company was excavating the dirt, it found an ancient boat underneath the ground, which was very valuable. It could be sold to a museum. But the court found that Mr. E had the best title to the boat because the boat was found on his land, even though he didn't do any digging or put any effort into finding it. Similarly, in the Waverley Borough Council and Fletcher case, Mr. Fletcher discovered a brooch, which is like a jewel. You can see people wear them. It's like a jewel that people attach to their shirt. Yep. Or their blouse. I think he was a metal detectorist, and he was out searching, and while he was looking with his metal detector, he found a brooch under council parkland, and the council had the best title to it because the council owned the land, even though Mr. Fletcher put the effort into finding it. And in Ranger and Griffin, workmen were digging under a house, and while they were digging, they found a tin full of money, and again, the owner had the best title to that. So those three preceding cases all involved things being found essentially in the dirt, in the property. What about if the item is found on someone's property? So it's not buried into the ground, it's sitting on the surface of the property. In that scenario, you need to consider whether the owner meets the control test. Okay, so the owner will have the greater rights if they can show that they were exercising control or dominion over that space. What does that mean? Let's look at Bridges and Hawkesworth. In that case, the finder of a roll of notes on a shop floor had the better claim. The shop owner did not know that the notes were missing, did not know that the notes were there, and they weren't in his custody. Therefore, the finder had the best claim. The shop owner could not show that he was exercising control or dominion over the space. Court reached a similar conclusion in Parker and British Airways. A lot of finders keepers cases, well, particularly if something is found on property or found on property, then you should be looking at the Parker case. So Mr. Parker was in the British Airways Executive Lounge, which I guess is a bit like the Qantas business class lounge, maybe equivalent. So he found a gold bracelet and he handed it into British Airways, but nobody claimed it. And so after a period of time, some months passed, and Mr. Parker asked, did anyone claim the bracelet? And the Airways said no. And Mr. Parker said, well, can you give it to me then? I have the best claim. I found it. The true owner can't be found. And British Airways refused to hand it over, and Mr. Parker took them to court. And the court considered the facts and concluded that British Airways was not exercising control over the lounge. So the lounge is a space where people who've paid a lot for their ticket generally, who are going to catch a plane or waiting to catch their plane. So it's a semi-public area, although it is a private restricted space in a way. But the court said British Airways was not exercising control over this space. They didn't have evidence that someone was regularly going through the lounge to look for lost property. They didn't have a lost property box. There wasn't like very regular cleaning or anything like that. Okay, but the court said if British Airways had been able to show that they were exercising control, then they would have been able to keep the bracelet. Okay, but in this case, they had to hand it over to Mr. Parker. There was also some observations in that case which might be relevant for you in an exam question and certainly for the tutorial potentially next week. So the court said we can't presume control in this context, but we would assume that if an item was found in a private home, that the lawful occupier of that home intended to exercise control or dominion over that space. Similarly, a bank vault. There's an intention by the bank in such a secure environment to exercise control or dominion. So you don't need to apply the control test if it's a private home or a secure facility or a bank vault. But if it's not one of those types of spaces, then you would need to look at the evidence in the question to determine whether the airline was exercising control. Okay? Ooh. Okay, and let's look at Chairman and the National Crime Authority and FLAC. This is in your textbook as well. Probably one of the more entertaining cases, I think. There's a lot more to the story than is actually extracted for us. Now, the National Crime Authority suspected Mrs. Flack's son had committed some drug offences. They suspected that he was dealing in illicit drugs, and so they had a warrant to search her home. Her son didn't live with her, but he did visit her regularly. And while they were searching her home, they found in a cupboard a locked suitcase that had, I think it was $433,000 in it. And that was in 1998. So nearly $500,000 in the suitcase. Mrs. Flack said, I don't know what that is. I've never seen that before. I don't know how it got there. That's not the cupboard I usually use to get the sheets. And her son and daughter also said, well, I don't know what that is. So the crime authority seized the suitcase and kept it. And no one else came forward to say that they owned the money. And separately, the prosecution against the son didn't proceed. So there mustn't have been enough evidence, or the DPP decided not to prosecute. So after a period of time, Mrs. Flack wrote to the National Crime Authority and said, could I have the suitcase back, please? I was the lawful occupier of the home. The true owner has not come forward. And the National Crime Authority refused to. So she brought an action. And the court had to consider, was Mrs. Flack entitled to the money? So the first thing they had to ask was, well, was Mrs. Flack the lawful occupier of the premises? And the answer is yes. And keep in mind, lawful occupier, you don't necessarily have to be the owner. You could simply be there lawfully as a leaseholder, as a tenant. And secondly, they had to think, well, did she have an intention to exercise manifest control and dominion over the home? And they looked at the Parker case and found that, well, the court has said that there's a presumption that a lawful occupier intends to exercise dominion over their home. Therefore, the court concluded that Mrs. Flack was entitled to the money in the suitcase. And the suitcase as well, although perhaps that was not as quite important to her. So you can use this case, I guess, as further authority for the principle that there's that presumption that the lawful occupier will meet the control test and does have the best claim to anything found on those premises, even if they didn't know that it was there. Okay, what about finders when they find something during the course of employment? So the general rule is, if you find something during the course of your employment, you need to hand it over to your boss, to your employer. But if what you found was incidental to your employment, not because of your employment, then you get to keep it. So what does it mean to be in the course of? So Wiley and Simon, I've got another old English word. Have you heard of stowaways? So a stowaway is someone who sneaks onto a ship to get free passage. Okay, so they sneak onto the ship so that they don't have to pay the fare. Now, the employee was paid. His employer said, go and check the hull of the ship, that is the base of the ship, for stowaways. I want you to go and look in that area and see if there's anyone who's tried to sneak onto the ship without a ticket. So his job was to go and look in the hull, and while he was doing that, he found a bag of coins. And he wanted to keep them. And the court said no, because you found it in the course of your employment. The only reason you were searching the ship was because you were paid to search the ship. Okay, and while you were doing that, you found the coins. Therefore, you have to give them to your employer. Now, burn and whore is a different scenario. So, I feel like there's another history lesson. So this is in the 1960s when people had, is it a Queensland case? I think I'll find the link for you. I can't remember if QD is Queensland. I think it is. It's a Queensland decision, but it possibly is UK. I'll confirm that for you. Anyway, it's a drive-in theatre. So people drove their cars to watch the movies, and they'd watch the movie in their car. And the policeman's job was to direct the traffic at the entrance about where to park in the drive-in theatre. Now, on his way, so he parked his car, on his way to the theatre entrance where he was going to direct the traffic, on a public footpath or where the public were walking, he found some gold. And he wanted to keep it, and that his employer wanted him to hand it over. And the court found that his finding of that gold was incidental to him doing his job. He found it where any member of the public could have found it, and it was on his way to start his shift for directing the traffic. It wasn't while he was actually directing the traffic. So the court found that being on duty at the theatre was not the real cause of him finding the gold. It simply gave him the opportunity to find the gold. He had not acquired possession of the gold by reason of the fact that he was a policeman or in the performance of his duties. So importantly, it was not one of his responsibilities to look for lost property. And the fact that he was on duty when he found the gold was merely coincidental. He was in exactly the same position as a casual passerby. So another person of the public could have found it. Therefore, he could keep it. Okay, and there's a quote in the textbook from Justice Gibbs. To give the master, the employer, a right to a chattel found by his servant, an employee, it is clearly not enough that the servant happened to be going about his duties when he found it, for the fact that he was performing his duties may have been accidental and not the cause of the finding. So that's the test you'll need to apply in the exam. Why did they find it? Was because they were doing their job? Was that a necessary precondition? And simply comparing those two cases and then applying your own reasoning based on the facts. If it was an employee finding something will be enough for you to get the marks that you need. Has anyone got any questions about finders keepers? Okay, there's some tutorial questions on it, so you can practice that again. I just want to talk briefly about mortgages, which are important in a property context. I think this is the third or fourth time that I've talked about mortgages and guarantees. We've talked about it in the context of equity, also in the context of unconscionable conduct in contract law. And so some of the cases I'm mentioning now you've already seen earlier in this course. So under the Torrens system, which is the system we have for registering land ownership, a mortgage is a statutory charge and ownership of land remains of the borrower. So the person who's taken out the loan keeps ownership of the land, but the lender, the bank, has a charge on that property. So if the property is sold, they have a right to take the money that they are owed. If there's a default, so if the borrower doesn't meet the terms of the contract and doesn't repay the money on time, for example, then the lender, the bank, can sell the property. They have the power of sale. They've got the right to sell the property to satisfy the debt. So I guess make a note for yourself perhaps that if there's a mortgage question in the exam, it's possible that you'll need to look at both contract law and property law potentially, and perhaps also equity. Not necessarily, you don't know what the question will be, but certainly be aware that it won't just be one of those weeks usually. Now, if a bank is exercising its power of sale because there's been a default in the payment, the bank has an obligation to act in good faith. And in the context of mortgages, that means that the bank must make sure that the property is accurately advertised. So if the property has 5 bedrooms and a pool, it shouldn't be advertised as only having 3 bedrooms, for example. And it also needs to be advertised for a certain period and in the right sort of papers and so on, to make sure that that potential buyers are aware that the property is available for sale, and that the bank has done what it can to ensure that the defaulter, the person who owns the property, gets a reasonable or best price for that property. Okay. Of course, if you didn't have this duty of good faith, there's no financial incentive for a bank to get the best price for someone. So if the property is worth $1 million, but the bank is only owed $200,000, say it did sell for $1 million, that $800,000 would go to the defaulter, to the owner. Okay, but the bank really would have its own debt satisfied if it just put it on the market for $200,000, right? It would sell extremely quickly, there'd be no advertising costs, and they'd have the money right away. But because of the duty of good faith, banks cannot do that without legal consequences. And the Nixon case illustrates how the court might approach the duty of good faith. The Nixon case was based in the context of Queensland legislation, but it's still a useful case for us to illustrate good faith and how that operates. Although in the ACT it's a common law obligation, not legislative. It's a 1981 case, it's quite old. So there's a caravan park that was being sold by the bank because there'd been a default, and it was in Bundaberg, Queensland, which is some distance from Brisbane. The park was sold by auction. The auction was advertised for several weeks in the local paper, but it was only advertised in the capital city paper, which I guess must have been the Courier Mail, but in the Brisbane paper 2 days before the auction sale. And the property was sold for $55,000, but the evidence was that if it had been properly advertised, its real value was closer to $80,000. So Mr. Nixon brought a case against the bank, and the court found in his favour and said that the bank had not taken adequate steps to advertise the sale. Therefore, Mr. Nixon was entitled to the difference between what he could have got if it had been advertised properly, which is another $25,000. So that was the remedy that was granted. I've got a note there for you just about how that one is limited to, or was based on the Queensland legislation. It's still perfectly fine for you to refer to it in an exam. I don't actually have any ACT cases on that point, possibly because the banks are aware of what their duties are when it comes to default mortgages, and so there's relatively little breaches of that good faith principle in relation to that particular circumstance. Now, you also need to know about guarantees, and you have heard about guarantees in the context of the Amadio case. Remember Mr. Amadio and his elderly parents, and the court found the bank had acted unconscionably. So what happens in a guarantee? So the debtor, the person taking out the loan, who's called the principal debtor, promises to repay or perform other contractual obligations to the creditor or the bank. And the guarantor promises to perform the obligations of the principal debtor if the principal debtor fails to pay the debt. So in the Amadio case, Mr. Amadio, Vincenzo Amadio, the son, took out a loan with the bank, and then his parents promised that if their son, Vince Amadio, did not fulfil his contractual obligations, did not make the repayments, that they would make the repayments. And if they couldn't make the repayments, then their investment property could be sold by the bank because it was offered as a guarantee. I would recommend not ever going as guarantor, because if the bank has determined that someone is not good enough to lend money to, so they want extra assurance, maybe you should think twice about how risky that is for you to be offering that assurance. Okay, there's a little bit more information there for you on that slide. Now, often if there's a guarantee situation in an exam or even in real life, there will often be claims of unconscionable conduct, okay, which is exactly what happened in Amadio. And it's usually because the guarantor, so in the case of Amadio, Vince's parents, don't get any obvious benefit from the transaction. So in order for a bank to try and avoid an unconscionable conduct claim, the bank should take particular steps to try and assure itself and potentially assure the court that the guarantee was given freely and that the guarantor understood the consequences of going as guarantor. And you'll recall from the Amadio case that the court decided that the guarantee given by Mr. and Mrs. Amadio was not enforceable due to the unconscionable conduct of the bank. Do you remember what the court said made the Amadios particularly vulnerable, that the bank took advantage of? Language, yep, so they were not fluent in English, they spoke Italian, they didn't quite understand the transaction, and that was obvious to the bank manager at the meeting. And also they weren't sophisticated when it came to business matters, they didn't really understand much about the business. And yes, the bank certainly, if it wanted that contract upheld, should probably have made sure they got independent legal and financial advice and had a certificate from an accountant or lawyer advising that that advice had been given. Okay, now there used to be some presumptions about guarantees when it came to women, when it came to wives who offered guarantees for their husbands' businesses. And this originated initially in, well, probably the most significant Australian case, although it had been a presumption that had been around for a very long time, was in the Yerke and Jones case. So the principle in the Yerke and Jones case was that a married woman might be given special treatment in terms of avoiding the guarantee. So if you were a married woman who offered a guarantee perhaps on the family home that you were a joint tenant in, if you offered a guarantee so your husband could get loans for his business, the courts were more likely to set aside that guarantee on this assumption that if a wife guaranteed her husband's debts, she was probably subject to undue influence, and it would be unconscionable for the banks to rely upon that guarantee in the event of default. So the court had to consider in the Garcia case, and you can see here, see how it says CLR in the case citation? That's Commonwealth Law Reports. These are High Court cases. They're setting a precedent for the whole of Australia. In the Garcia case, 1998, things have moved on since 1939 with Yerke and Jones. The court had to consider, well, how does Yerke and Jones apply in a more contemporary context? And in this case, the National Australia Bank had made loans to Mr. Garcia's companies. Mr. Garcia and Mrs. Garcia were directors in these companies, but Mrs. Garcia was what you'd call a silent director. She didn't participate in the business of the company, but she was named on the company records. Mrs. Garcia gave 4 guarantees in relation to the loans. You can probably guess what happened next. Things only end up in court when they go badly. The husband defaulted on the loan and the NAB attempted to enforce the guarantee offered by Mrs. Garcia. And the court held that that guarantee could not be enforced. Mrs. Garcia was not liable. And this was because there was sufficient evidence to show that she didn't understand the effect of the guarantee and that the bank had made no attempt to try and explain it to her. And then the High Court stated that its decision rested on the trust and confidence between marriage partners, and that one marriage partner may exploit the trust and confidence. So applying the Garcia case, the presumption no longer just relates to married women, it could also relate to a married man, and arguably I would say to partners in a de facto or domestic relationship. Okay, so if you have a relationship of trust and confidence, it's not actually related to gender, then perhaps the guarantee would be set aside depending on the circumstances of the particular case. But it's important to note that simply the fact that one party to a marriage or to a domestic partnership has signed a guarantee is not enough on its own for that transaction to be set aside. Okay. If the bank could show that the person signing the document knew what they were signing, had a degree of sophisticated understanding of business, then the transaction will not be set aside. It comes down to evidence. And in the Westpac banking case, the Westpac successfully argued that even though the wife offered a guarantee, she still obtained a personal benefit from that transaction. And also the bank showed that the wife understood the practical effect of the mortgage transaction. So she knew what the consequences of that agreement were. So banks are much better now at documenting the evidence, at documenting the ability of the guarantee and the guarantor's understanding of what transaction they're entering into. Adverse possession, I've just put that there. If you're looking for something entertaining that's still loosely related to the course, feel free to follow the link. It's a really interesting area of law that unfortunately doesn't apply, has never applied in the ACT because we are Torrens title, have a Torrens title system, but it has applied elsewhere in Australia. But it's not accessible, so I will just move on to the questions. Okay, and let's just skip ahead from Alan and Beth and go straight to the 2016 exam question. We're actually going to go through it and do it now. So I'll just read it out and I'll get you to guess the legal issue, and then I'll go to the right slide and perhaps you can have a go at applying it with the person next to you. So we've got a company that's taking photos by drone of the Floriade Flower Festival. I think the Floriade Festival is still on at the moment. If you like flowers and crowds, it's free. You just need to go over Commonwealth Avenue and it's on your left. James owns his home in Reid, a Canberra suburb bordering the Floriade Flower Festival. The drone piloted by Nick crosses James's property every day in September. The presence of the drone has upset his young children and scared the native birds away. James feels like he can no longer enjoy spending time on his property. Is there any legal action James can take? And would your answer be different if James and his family were away while the drone is flying over his property? So if you can't remember the case, but you can kind of guess the area of law, does anyone want to have a go? And then I'll go to the slide. We're looking at James's rights to airspace. Excellent. And does anyone remember what case you always need to start with when you're looking at rights to airspace? Bernstein and Sky Views. Excellent. You're halfway. Well, you're almost there. I was saying to someone this afternoon, the hardest thing with the exam, and if you can do this, you really can be quite confident that you will pass if you just keep studying, is identifying the legal issue. Because once you've identified the correct legal issue, you're on your journey to find the right case, and then hopefully it'll all come back to you and you'll correctly apply it to the facts to reach a conclusion. So well done on those of you who identified it's about a rights to airspace, that we always start with Bernstein and Sky Views. Okay, so the rule is there. What is the general rule? What are we telling James if he comes into our office and we're lawyers and he's complaining about this drone that's scaring away the birds and it's making his children upset? What are we telling James about his general right to airspace? What are the limitations upon his rights to the airspace above his land? Excellent. So I gave you a little clue in the question because I said James feels like he can no longer enjoy his property, which hopefully was a clue that led you to Bernstein. But excellent, that's a great description. So James's rights to the airspace are limited to what interferes with his enjoyment of the property. What do you think? So you're now in the application phase. So you've got the law, the application. You might also, it was still probably possible to get a HD, I think, maybe a very good distinction. You might note at this point that James can potentially also seek to negotiate with PFL to grant them a licence to fly over his property, maybe. But I think James is not really looking for money here. What do you think James wants as a remedy? An injunction. James wants the drones to stop, most likely. Okay, so do you want to just take a moment to think about your application? Is it interfering with James's enjoyment of his property? Yes? No? So enjoyment's not just about him feeling happy and joyful on his property. It's about his use of the property as well. So can he use it? Can his children play? Can he enjoy the birds? No, because the drone is scaring them away. So arguably, so this is different. You can distinguish the facts from Bernstein, because Mr. Bernstein didn't even know the plane was coming overhead, right? So you can distinguish the facts from Bernstein and say, in this context, James's enjoyment of his property is being interfered with. His children can't play on the land. The birds are gone. Therefore, there probably is trespass, and will probably be successful in seeking an injunction. Okay, the next part you were asked is, well, would your answer change if James is away in September with his whole family? So if James is away and his children are away, who's being impacted by the drone? The birds. So, and answers could differ on this point. I think you want to start off by saying, yes, my answer probably would change because it's not really affecting James's enjoyment and use of his property if he's not there. But maybe if the birds are scared away forever, then maybe that would interfere with his enjoyment. Okay, does anyone have any questions about that one? All right, excellent. Just close your eyes while I flick through because it might flip. Oh no. Okay, let's have a look at Miss Scarlett. We might have time to do everything. It's still pretty early. So this is a 2017 exam question. It's a property question. Miss Scarlett, these questions were all kind of Cluedo characters, and it was set in an escape room. There are escape rooms in Canberra. You have to go into the room and work out the clues to get out of it. So Miss Scarlett works at the puzzle room. Her boss is Mr. Plum. She's leaving work, and on her lunch break, on a public footpath, she finds a gold ring. And she takes it she asks the people around her, is this your ring? And they all say no. So she takes the ring to a jeweler for valuation. The jeweler decides to keep it, but at the same time her boss says, you should have given it to me. And you're asked, who has the best claim to the ring? And really, I should be asking, who has the second best claim to the ring? So who has the best claim to the ring? No. Who has the best claim? Okay, they're not mentioned here. They usually can't be found. Who has the best claim to the ring? The true owner, okay? So just remember that. Finders keepers, you always say the true owner has the best claim. However, if they can't be located, Miss Scarlett. So why do you think Miss Scarlett has the best claim after the true owner? So I agree. I think Miss Scarlett here does have the best claim after the true owner. Why? She's the finder, okay. Do you remember what case you would probably use? Chimney sweep case, Amory and Delamere, okay. Finders generally have the best claim. This is actually a little bit similar to the chimney sweep case because she has taken it to a jeweler, okay. And why, why doesn't, where was it found? On a public footpath, okay, so we're not thinking about occupiers as such, and it's found on the footpath, not under or in the footpath, so we're not thinking about landowners. And why do you think Mr. Plum doesn't have why doesn't her boss have a claim to the ring? Yeah, it's not within the scope of her employment, so you'd apply Byrne and Hoare, okay. You could mention Wiley and Simon for good measure, but Byrne and Hoare. That's fantastic. That's really good. Does anyone have any questions about that case? Okay, there's another. I'd encourage you, it's the very last case, last question in 2017 semester 1, which I've uploaded, is another property question with a slight twist on these facts. Go on there and have a look and see who you think has the best claim. Okay, let's have a look at Trish, who lives in New Acton. She discovers a drone on her balcony. There's probably a few facts you don't quite need there, the next sentence. The drone must have run out of battery and it's just collapsed on her deck. So can Trish keep the drone? I guess that's our legal issue. If you're not sure of the case, you can just tell me the legal principle. What rule would we be thinking about when we're wondering whether Trish can keep the drone? Or if you don't even know the rule yet, you can tell me your gut instinct. Sorry? National Crime Authority and FLAC? Yep, excellent. So what's the presumption that we can have because of FLAC?
It's on the property. It's found on the property which is in possession of FLAC.
Excellent. So there's a presumption that if Trish is the lawful occupier of the property, and because we're told she rents it, she is. So if Trish is the lawful occupier of the property, she intends to exercise control or dominion over her property. Therefore, she has the best claim to anything found on her property. You would also be mentioning Waverley Borough Council at this point. What are some of the obligations that Trish has as a finder? Even if she's got the best claim, what are her obligations? Okay, so she has an obligation to try and find the owner. You don't need to go, it depends on the question, I guess, but you don't need to say exactly what she needs to do. Like, does she need to put an advertisement in the paper or a Facebook post or whatever? But you can just say she needs to make efforts to find the owner. And what else does she, what's her other main obligation as a finder? She has to maintain the property. So, for example, she needs to bring it inside and make sure it doesn't get rained on or something like that. She needs to look after it. You can kind of get rid of that obligation if you yourself have found something just by taking it to the police. But yeah, those are her obligations. Excellent. So that was great. Make sure you kept the case law in your decision as well. And you might notice then that the students and I, we mix together our application and our law. That's fine. You can do your application law in one go. What about if Trish's cleaner found the drone? So what's the general principle if you find something while you're working? So generally you need to give it to your boss, but I guess your little mini, what's your mini legal issue here when you're thinking about the cleaner? Yeah, or course of employment. Yeah, did the cleaner find the drone within the course of her employment? What do you think? What's she doing when she finds it? She's sweeping the balcony and she found it. Therefore, so we would be applying Burn & Hore, Wiley and Synan. So what's our conclusion? Is our answer going to change if Trisha's cleaner finds it? No. Applying Wiley and Synan, she found it within the course of her employment. She's obliged to give it to her employer. Her employer is Trish. Trish still has the best claim, assuming Trish is her direct employer. But that's a complicated issue you don't need to worry about. Does anyone have any questions about that? Yep. What if what, sorry? Oh, yeah, well, what do you think? I think if there's no security cameras, does anyone even know that you ate it? Well, food is still a good. So the principle, I mean, all of these cases involve valuable items because you're not going to go to court over a sandwich, right? But the principles are the same whether it is a very valuable item or not a valuable item. It's still a good. It's still a chattel.
Is there any note the time that you can find the owner and after that if nobody thinks that then you can, is there a time?
So the police might have their own timeframes for when they would give it over to you, but for our purposes, I think you just make reasonable efforts, and if after a reasonable period of time, which is not prescriptive, you can keep it. Yep. I certainly don't have any case law to tell you a precise amount of time that you can keep something before it becomes yours, but the answer would be reasonable. Yep. I hope that's helpful. Does anyone have any questions about this one? Okay, so let's go back to Alan and Beth. So this is fixtures and fittings. Those questions I just went through with you, I wrote for previous exam papers. The next two, the Alan and Beth cases, the questions are at the end of chapter 20 of your textbook. Okay, so Alan and Beth are buying a house. They're very impressed with the kitchen because of the oven, dishwasher and microwave, and the lounge because of the carpet and the drapes. Drapes are sort of like curtains. Do these things come with the home? If not, is there a way to ensure that they do? Let's just jump to the second question up front, okay? Because we'll have to work out which of those things are fixtures and fittings. But first off, if something is so if it's a fixture, it comes with the home when you buy the home. If it's a fitting, it won't automatically be included in the purchase. But it's important to remember there's a really quick workaround. If you're buying a house and you want to make sure something's included, what can you do? Yeah, add it to the contract. Okay, negotiate with the vendor and add a term to the contract that says all light fittings are included with the home, or the garden shed, or the outdoor patio pot plants. Pot plants aren't normally included. The pot plants are included in the home. Okay, so if you're in an exam scenario, like, they can always be added to the contract. Okay, but this is what is included. The question is about, well, what's included if all it says on the contract is, you know, the house and the land is for sale? What are you getting? Okay, so we know you're getting the house. You will get, is it fittings or fixtures that you'll get with the house? Fixtures. Excellent. Okay. Now, what is the case, and I can go back and show you the slide if you need to, but what is the name of the case that you always need to mention in the context of fixtures and fittings? APA and Coronio. We're nearly there, hang on. Okay, APA and Coronio, because it says in determining whether something is a fixture or fitting, you must always look at the degree of annexation, you know, the degree to which it's attached, and the purpose for which it was attached. And purpose will always be more important than the degree of annexation. Okay, so you start off with the APA and Coronio, and then you would definitely flick through to this section of cases 608 to 610 in your textbook. There's many more in the textbook than I put on the slides. And look, you probably, simply by applying APA and Coronio, Diencourt and Gregory, and Canadian Imperial Brank, you would be able to figure out pretty well what is a fixture and what is a fitting and get it right, okay? But these cases will save you time because you won't have to think as much. And they will also show your marker that you have a more deeper understanding of the law related to fixtures and fittings. But it would still certainly be possible to get good marks without mentioning these. But if you want to be looking at, good distinction HD territory, then you'd need to mention one of these as well. Okay, I'm not going to go back over the law of fixture and fittings. I just want you to now think about applying these tests to work out whether those particular items are fixtures or fittings. I would give you a minute to talk to each other, but I just want to keep going and make sure we get through all the content. So what do you think? I think we've got an oven. Is an oven a fixture or a fitting? Yeah, so it's totally fine and probably necessary to answer this particular question to say it depends. So if ovens usually in Australian homes are purpose-built in a particular special measured shelf and they're built in and they're not easy to pull out. So if you could say if it's in a purpose-built recess intended to permanently enhance the home, then it would be a fixture, the oven. What about the dishwasher? It depends. Yeah, so simply being attached to water and electricity doesn't make it a fixture. It makes you enjoy it more as a fitting, which is Siegel and Obsborn. But if it's in a special recess and cupboard and built in, then it would be a fixture. Microwave, what do you think? Fitting? Yeah, definitely a microwave would normally be a fitting, unless in the question I gave you evidence that it was a specially designed cupboard that it sat in or something. Okay, excellent. What about the carpet? Yeah, it depends. If it's just a rug on the floor, it is probably a fitting. If it's just sitting on the floor, it could be picked up easily, unless it contributes to the overall architectural design of the house, applying Diencourt and Gregory. If it's a carpet that's glued in and stapled into the corners, I would say that's meant to be permanently enhancing the home, so it's a fixture. Again, it could be either or. What about curtains or drapes? Usually they are fittings. They're easily removed, unless, again, they're part of the architectural design of the home. Okay, excellent. What about if they're renting? So to answer this question, you'd need to be looking at the Residential Tenancies Act. There's a bunch of case law, but really the Tenancies Act should be your focus. I'll just find you the slide. Okay, so we're asked, if Alan and Beth were renting the house and installed those things, can they take them with them? So first of all, Alan and Beth need to ask permission before they put in fixtures. If they're just plugging in a microwave, they don't need to get permission. They probably don't need to get permission for putting the curtains up. But generally they would need to get written consent. Consent can't be withheld. But the main thing we'd be saying to Alan and Beth is if you are going to take these things out when you leave, you need to do it before you go. You can't leave the property and then go back and get them. But also you need to make good. So if you've made any physical alterations in the home in order to install these items and you're going to take them out, you'll need to replaster or paint over so the wall looks like you never did it. Okay. Does anyone have any questions? Hopefully by going through the questions it gives you a little bit more confidence for the exam. I've given the previous exam paper with some guides to your tutors, so if you want to do some practice answers, feel free to go along to consultation and discuss them with your tutors and get some pointers as to what you're doing well and what you could do better. I'm definitely going to do all of the 2018 exam and some of 2017 in week 12, in the lecture in week 12, go through the answers with you. Okay, so that's it for today. Has anyone got any questions generally? Okay, I'm happy to wait a couple of minutes if you want to come up and talk to me. Did you have a question? No. Hi.
So finally, for them, they should remove these items before the time the hot to
Yep. Yeah, that's right. I'll show you the legislation. I'll put it both. Oh, it's on the slides, really. Yeah. This is what you have. Oh, under the torrent system, tenants fixed it. Yeah. So anything they need to remove them at the end of the lease, and they have to make good.